At Gateway Pacific Law Group, we pride ourselves on supporting California workers by not only representing them and asserting their rights, but also educating workers about their rights as employees, including workplace safety laws. In this video, we will summarize some important California workplace safety regulations such as different occupational standards, an employee's right to a violence-free workplace, heat safety, the role of CAL-OSHA, and what options are available to employees working in an unsafe environment. Remember, the information presented in this video is for educational and advertisement purposes only. Go to our Linktree address after you view this video to check out our website and social media accounts. There, you can level up your knowledge on California's workplace safety laws. We even have some handouts you can download from California's Occupational Safety and Health Administration, also called CAL-OSHA. You can learn even more details and get some web links to key workplace safety sites. Plus, you can find other employment law-related topics and even helpful documents to download. Also, stay tuned so we can tell you how you can have a chance to win a $50 Visa gift card. Now, let's talk about California's workplace safety laws. CAL-OSHA enforces workplace safety standards across the state of California, and some of the key safety regulations employers must adhere to are as follows. The Injury and Illness Prevention Program, or IIPP. Every employer in California must establish, implement, and maintain an effective written IIPP. This involves identifying and evaluating workplace hazards, implementing necessary safety and health training, and maintaining records. Every employee has a right to review their company's IIPP. Emergency Action Plans, or EAP. For businesses with more than 10 employees, a written EAP is mandatory. This plan ensures that employees know what to do in case of emergencies like fires, earthquakes, or chemical spills. The EAP must be in writing, it must be kept in the workplace, and it must be available for employees to review. Hazard communication. Employers must inform their workers about chemical hazards they could be exposed to. This includes proper labeling and having safety data sheets available for all hazardous chemicals located at the work site. Finally, employers must provide appropriate training in the handling of hazardous chemicals used or kept on the work site. Personal protective equipment, also known as PPE. Employers must provide and ensure the use of appropriate PPE for jobs that require it, from hard hats and safety goggles to respirators. Reporting and record keeping. In the unfortunate event of a severe injury, illness, or death, employers are obligated to report to CAL-OSHA within a specified time frame. All employers are required to notify OSHA when an employee is killed on the job and must be reported to CAL-OSHA within 8 hours. All employers must also report when an employee suffers a work-related hospitalization, amputation, or loss of an eye. An inpatient hospitalization, amputation, or eye loss must be reported within 24 hours. You have a right to a violence-free workplace. It's crucial to recognize that every California employee has a fundamental right to a workplace free from violence. This is not just a moral obligation, but also a legal one for employers. Workplaces where employees are vulnerable to violence, such as healthcare facilities, late-night retail establishments, and certain public service roles, must have a written workplace violence prevention plan in place. In tandem with this, the employer is required to assess the workplace to identify factors that might put employees at risk of violence, educate their employees about their rights and what constitutes workplace violence, and implement preventive measures to mitigate these risks. Before we talk about heat protection regulations, don't forget to hit that subscribe button and ring the notification bell so you won't miss any of our future videos tackling important legal topics. Heat protection. Did you know the California law requires most employers to implement heat-related illness prevention policies? Employers must have a policy to prevent heat-related illnesses for employees who work both indoor and outdoor. Some regulations include providing employees access to cool drinking water and permitting employees to drink water every 15 minutes, even if they aren't thirsty. Ideally, employees should be permitted to drink 1 quart of water per hour. Most regulations are triggered when outdoor temperatures reach 80 degrees or above. However, employers like warehouses also have to carefully monitor indoor temperatures because machinery and ventilation can trigger heat prevention regulations also. When the outdoor temperature reaches over 80 degrees, most employees working outdoors must be allowed access to shade, and they must be given cool-down breaks of at least 5 minutes before the employee starts feeling ill. Before we talk about what employees can do if their rights are violated, if you find value in this video and you want a chance to win a $50 Visa gift card this week, please give this video a thumbs up and comment on what legal subjects you want to see in the future. We pick one new winner for each video. We pick one new. So what do you do if you see an unsafe condition at work? If you, as an employee, believe your workplace is unsafe, then you should first report the unsafe condition to management. Initially, address the issue with your supervisor or human resources department. They may not be aware of the hazard, but if they are and they don't care, like maybe this guy, then you have to escalate the complaint. And file a complaint with CAL-OSHA. If the issue is not resolved internally, you have the right to file a complaint with CAL-OSHA, who will then investigate the matter. You are protected against retaliation. It's illegal for an employer to retaliate against an employee for filing a complaint about workplace safety. If you believe you've faced retaliation, you can file a complaint with the Labor Commissioner's Office at the California Department of Industrial Relations. If an employee suffers injury or illness due to workplace conditions or employer negligence, they can seek workers' compensation benefits. However, in some cases, if a third party or egregious employer negligence is involved, the employee might pursue a civil lawsuit. Monetary compensation from these suits can cover medical expenses, lost wages, pain, suffering, and sometimes punitive damages. If you were fired for filing a complaint with the Labor Commissioner, you can sue your employer for retaliation. Depending on the facts, your employer may have to pay you back pay, including the value of lost benefits, future lost pay, and general damages, like emotional distress. You may even be entitled to seek punitive damages if the employer's act was really bad. California's workplace safety laws are designed to protect the state's workforce from harm. By understanding these regulations and rights, both employers and employees can contribute to a safer, more productive working environment. If you think your rights have been violated or you need legal advice, consider reaching out to a professional who is familiar with this area of law, like Gateway Pacific Law Group. Visit our Linktree to find us on the web or call us at 562-485-6151. If you found this video helpful, please hit the like button. It really does help the channel to continue producing videos with valuable information. Also, please comment and let us know if you've experienced anything similar or give us some ideas for future videos. Share this video with your friends and family, or even better, on your social media pages, because you never know who this information might help. Finally, subscribe to our channel and hit the notification button so you get updates when we post videos on legal topics that are relevant to you.